Court calls the case People versus Michael Donner.
And then on behalf of people, Your Honor.
Good afternoon, Your Honor. James Fifelski on behalf of Michael Donner, who's to my right. Please state your name.
Michael Donner.
Your Honor, we're ready to proceed with exam on this case.
Your Honor, at this time, if you are unable to see this to counts 1 and 2, to ask for count 3 to be remanded down to district court.
We move for dismissal of counts 1 and 2. I would like to address bond on count
If
3.
it's going to be that same argument, we're going to have a problem.
Well, it's slightly different, Your Honor, because of these
Counts
circumstances.
1 and 2 are dismissed. I'll continue with not guilty plea. Wow, what is count 3? What do you have as count 3?
Domestic violence, first offense.
That's what I've got to, Judge.
No,
This is wrong.
that's wrong.
This is wrong.
Those are 1 and 2, and it's a DV. They never included count.
Court began with immediate confusion over the charges in People versus Michael Donner. Defense counsel announced they were prepared to move forward, but the prosecution stated they could not proceed on counts 1 and 2 and instead requested that count 3 be remanded to district court. The defense quickly moved to dismiss counts 1 and 2, which the judge granted. However, the courtroom then discovered a clerical issue. The charging documents appeared inconsistent. There was confusion over whether count 2, interference with electronic communication in a domestic violence context, had been properly entered. The judge halted proceedings to verify whether the judicial system records accurately reflected count 3 before continuing. Once clarified, the defendant entered a not guilty plea to count 3, and the matter was scheduled for a pretrial before Judge Freshour on January 15th, 2026 at 10:30 a.m., setting the stage for a tense bond argument.
2. Well, no. Yeah, they never included the real count 2. And so count 3. Sorry. Got it. Count 2 was interference with electronic communication. Actually, there it is. It's right there, but they got it entered there wrong. Can you check? Did this come directly from JS? Can you check what JS has?
This is a separate document by the clerk's
Right.
office. Not from JS.
Right. So check to make sure JS has a 3. Because otherwise they're going to have to correct something. I'll continue the defendant's not guilty plea as to count 3. Set this for pretrial on before Judge Freshour. January 15th, 2026. At what time? 10:30. Before Judge Freshour. As to bond.
Your Honor, is that at 1484 or 3?
It's a 1484 case.
Thank you, Your Honor. Your Honor, as to bond, I would ask, given the circumstances that 2 felonies were dismissed, and this is a unique situation in terms of, I think, much more hardship to my client's family, including his wife, than to him himself. His mother-in-law has reached out to me to beg me to try to get him out of jail to take care of this family. His wife is a single.
Defense counsel immediately pivoted to bond, emphasizing that 2 felony counts had just been dismissed and arguing that continued detention would cause extreme hardship to the defendant's family. He described the defendant as a sole breadwinner for a stay-at-home wife and 5 young children, adding that even the defendant's mother-in-law had pleaded for his release so he could support the household. Counsel proposed strict conditions: residence with his mother in Chelsea, electronic tethering, and court supervision to ensure compliance. He stressed that the defendant had previously turned himself in and had never failed to appear. However, the judge sharply interrupted, pointing out that this was not a single mistake. There had been 2 bond violations. The court expressed concern that the defendant simply did not believe he had to follow court orders, a far more serious issue than financial hardship.
He's the sole breadwinner. Even if she has to get a job for the next 3, she's got to pay extra daycare expenses to get these kids daycare because otherwise she would be taking care of them while my client's out working. I just spoke to his mother who said he could reside with her in Chelsea. I've got an address. I'd ask the court to tether him to the address, allow him to work. The court can assess his whereabouts and ensure he doesn't violate anything. He has never failed to appear at court. He turned himself in on this original warrant, I believe. And I understand we had a bond violation before, and I would just,
Well, two of them. It's not just one.
I
He just doesn't
understand.
think he has to abide by the court's orders. That's the problem.
Well, I don't think it's that. I think that he had poor judgment in terms of how he went about what he had to do just to get some things and see his kids. And I understand it is a violation. But he has now spent the last 12, 13 days in custody. That certainly sends a strong message. And just, again, we're talking about Christmas time. And he's got 5 young kids who rely on him to take
I
care
don't
of
know
their
how many
financial
women are going
needs.
to die over the holidays from somebody that's a domestic abuser either, Mr. Fikowski. So I don't think we ought to be using Christmas time as some type of mitigating factor.
Well, I would just,
The prosecution forcefully objected to any bond reduction, outlining the violations in blunt terms. At arraignment, the defendant had been clearly ordered not to contact the alleged victim except through approved third-party communication regarding child care. He violated that order almost immediately by making prohibited contact. After bonding out, he then returned to the residence he was explicitly forbidden to visit. The prosecutor argued this showed a pattern. The defendant could not follow basic judicial instructions. The judge echoed that concern, warning defense counsel not to rely on holiday sympathy. In a powerful moment, the judge stated she did not know how many women might lose their lives over holidays at the hands of domestic abusers, making it clear that Christmas would not be used as a mitigating excuse in a domestic violence case. The courtroom fell silent as the seriousness of that statement settled in.
ask, given the fact that it is but given the fact that, yes, the young children look at this as a special time, and I get it. My client is the one who made whatever decisions he has, but he's certainly willing to do whatever the court requires of him to ensure his appearance and safety in the community.
Response from the people.
Your Honor, at this time I would object. It was 2 clear bond violations. He was given clear instructions at arraignment not to contact the victim except for third-party contact about child care. He broke that, and then he was at the residence. And I mean, it can't be any more clear. He was seen leaving the residence he was told not to do. So I have concerns he can't follow court orders because he broke 2 of the conditions he was given at arraignment almost immediately after arraignment. The first being the calls, and then after he gets out of jail, bonds out, he goes right to the house. So at this time, I'm going to object because I don't think he can follow court orders.
His bond at this point is sitting at revoked. I will grant him a bond on this case. I'll grant him a $50,000 10% bond. Same conditions apply. I'll just say this: if you don't listen to him and you get before Judge Freshour, you're going to have heck to pay. You think this was rough. I would indicate that there will be a GPS tether prior to release. That GPS tether, I am not going to give a release to work. I'm going to let Judge Freshour make that decision as to how far out he can go and what he can do, because he just can't seem to follow anybody's instructions. So I think it's probably better that it come from her. So it's going to be a GPS home confinement and with no release for anything at this point until he receives permission of the court to do so.
Thank you, Your Honor.
Thank you.
Despite strong objections, the judge ultimately reinstated bond at $50,000 with 10% provision, but imposed strict conditions. The bond would include GPS tethering with full home confinement, and there would be absolutely no work release unless later approved by Judge Freshour. The judge warned the defendant directly that if he failed to follow orders again, the consequences would be far harsher next time. She made it clear that any future leniency would depend entirely on his compliance, and that further violations would not be tolerated. The decision balanced accountability with one final opportunity, but the message was unmistakable. This was a defendant's last chance to prove he could obey the